On January 20th, 2025, President Trump issued Executive Order 14160, protecting the meaning and value of American citizenship. This order reflects the original meaning of the 14th Amendment, which guaranteed citizenship to the children of former slaves, not to illegal aliens or temporary visitors. Multiple district courts promptly issued nationwide or universal injunctions blocking this order, and a cascade of such universal injunctions followed. Since January 20th, district courts have now issued 40 universal injunctions against the federal government, including 35 from the same 5 judicial districts. This is a bipartisan problem that has now spanned the last 5 presidential administrations. Universal injunctions exceed the judicial power granted in Article 3, which exists only to address the injury to the complaining party.
So as far as I see it, this order violates 4 Supreme Court precedents.
Yeah,
and you are claiming that not just the Supreme Court, that both the Supreme Court and no lower court can stop an executive from universally from violating those holdings by this court.
And you know, look, there are all kinds of abuses of nationwide injunctions. But I think that the question that this case presents is that if one thinks that it's quite clear that the EO is illegal, how does one get to that result, in what time frame, on your set of rules, without the possibility of a nationwide injunction?
On this case and on many similar cases, the appropriate way to do it is for there to be multiple lower courts considering it, the appropriate percolation that goes to the lower courts, and then ultimately this court decides the merits in a nationwide binding precedent. You have a complete inversion of that through the nationwide injunctions where the district.
So, General Sauer, are you really going to answer Justice Kagan by saying there's no way to do this expeditiously?
Is there any reason why this court, and I gather that's your safety net, is that at the end of the day, whatever, however long the day is, this court can issue a decision and it will bind everything else. Is there any reason in this particular litigation that we would be unable to act expeditiously?
Absolutely not, Mr. Chief Justice.
Okay.
When were the first universal injunctions used?
We believe that the best reading of that is what you said in Trump against Hawaii, which is that Wirtz in 1963 was really the first universal injunction.
So we survived until the 1960s without universal injunctions?
That's exactly correct. And in fact, those were very limited, very rare, even in the 1960s.
But its approach would require citizenship to vary based on the state in which you're born, or even turn on or off when someone crosses state lines, raising serious and unanswered administrability questions, not just for the federal government, but also for the states. And it would offend the text and history of the Citizenship Clause itself. Since the 14th Amendment, our country has never allowed American citizenship to vary based on the state in which someone resides, because the post-Civil War nation wrote into our Constitution that citizens of the United States and of the states would be one and the same without variation across state lines.
Should we decide or make up our minds on the underlying birthright citizenship question without briefing and argument and deliberation?
I think that we would be very eager to do supplemental briefing on that. General Sauer noted that none of the parties had asked for cert before judgment. We couldn't because we keep winning. I will ask right now for cert before.
What was the
Where's 157 years ago, we came together as a nation post-Civil War and said never again were we going to debate whether babies born on American soil are entitled to the rights and privileges of American citizenship. And contrary to what the United States is saying, citizenship doesn't turn on or turn off when you cross state lines. Babies born in Philadelphia are subject to the same rights and privileges as babies born in New Jersey. And I have to say, it was astonishing to hear the United States government tell the 9 justices of the Supreme Court that they weren't sure whether they would follow binding court precedent.
And contrary to what Justice Sotomayor said at the very beginning of the oral argument, This is a question that the Supreme Court has never addressed in a holding. Never. Not in Wong Kim Ark. That case dealt explicitly with the children born of lawfully and permanently domiciled parents. The three other cases she cited were the purest form of dicta, just a statement in passing, no part of the holding of those cases. And I think the historical record is much stronger in favor of President Trump's executive order than the 3 or 4 justices that commented about the merits were willing to accept.